So good afternoon to those in the Far East, and good morning to all in Europe. It is quite late in the night for those in the Americas, and we will be recording this discussions for further viewing. I would like to welcome you all to this kickoff discussion on dispute resolution in the digital economy, hosted jointly with the Japanese Ministry of Justice, the Japan International Dispute Resolution Center, and the UNCITRAL Secretariat. My name is Jae Sung Lee, and I function as the Secretary of UNCITRAL's Working Group 2, which is currently preparing the expedited arbitration provisions. And today, I'll be moderating the session mainly as the timekeeper. Now, today's topic is quite broad, I would say. By dispute resolution, we're referring to all different ways of resolving disputes that arise in international transactions, as well as the means to support such resolution of disputes. Now, through various webinars held virtually, you will have heard about the remote hearings, online platforms, AIs supporting dispute management, and so forth. So that is the area that we're looking into. Now, by referring to the digital economy, we're referring to the contemporary era where the way we trade have changed dramatically, and particularly so due to the COVID-19 pandemic. The subject of trade has moved from tangible goods to intangible goods like data. Trading is conducted over digital platforms, and people are investing in digital currencies, and online communities are said to have influenced the stock markets these days. In a sense, we're in the midst of a dramatic change on who conducts trade, what is being traded, and how trade is conducted. Now, we're calling today's session a kickoff discussion because the UNCITRAL Secretariat will be holding a series of virtual sessions during the first half of the year to discuss these developments so as to inform the Commission when it meets in June this year to consider any future topics it wishes to embark on. Now, UNCITRAL, as you know, is an intergovernmental body established by the UN General Assembly to harmonize and modernize international trade law. And it is a body well known to you in the realm of dispute resolution. And thus, we at the Secretariat are keeping a close eye on these legislative and technical developments, and we'll follow them with great interest. And that is why we're kicking off this discussion today with this session. Now, with that short introduction, I'd like to give the floor to Madam Secretary, Ms. Anna Juban-Brett, the Secretary of UNCITRAL. Anna, you have the floor, and you have 8 minutes, Anna.
Thank you very much, Jay. Dear experts, delegates, and friends of UNCITRAL at large, good morning and good afternoon from Vienna. We're grateful to the Japanese Ministry of Justice and to JIDRC for co-hosting this kickoff discussion on dispute resolution in the digital economy. As this is a kickoff event, and my colleague Jay just mentioned it, the intention is not to go in depth into the topics we have on our agenda, but rather to provide an overview of the work that lies ahead of us, to identify possible synergies, complementarities, and see how best we can carry out this work and get organized. And for this, we of course need your views and your inputs. So thank you for being with us today. I'm happy to hear that we have about 450 or 500 people that have registered for this event. So that's very encouraging and heartening. Let me give you a brief overview of the current work of UNCITRAL and of the discussions at the Commission on possible future work. Two of our working groups, Working Group 2 and Working Group 3, are currently working in the field of dispute settlement, one focusing on expedited arbitration rules that will be brought to the Commission for adoption in July of this year, and another on investor-state dispute settlement reform. You will hear from Andres Hanna, the chair of Working Group 2, more about that, but I'm very pleased by the fact that the working group decided to address already the use of technology in expedited arbitration through an express provision. We've all witnessed how international dispute settlement has adapted to the pandemic, the use of digital technology during the proceedings, virtual and remote hearings, have been the focus of one of the virtual panels on COVID-19 recovery and response organized during the 53rd Commission session in July of last year. It's very clear that the pandemic has been a catalysator or booster of digital technologies in international trade and in cross-border transactions. Many instruments of UNCITRAL have been highlighted and cited as appropriate responses or contributors to a better way of tackling disruptions in international commerce that have been witnessed and continue to be witnessed because of the pandemic. It's therefore not very surprising that at our last commission, a number of proposals for future work that to be considered are relating to the response to COVID-19. And we have quite a lot on the table. Warehouse receipts, civil asset recovery that will also tackle digital assets, as Jay just mentioned, legal issues relating to the digital economy. Railway consignment notes are all legislative projects pending on the Commission's agenda, all closely address and involve digital technologies and their application to trade. Now back to dispute resolution. In 2019, we heard a proposal from Israel and Japan to work in the area of high-tech dispute resolution, which has been explored by the Secretariat under the broader umbrella of the Digital Trade Project in 2020. The Commission considered that the topic would benefit from further analysis in order to avoid developing sector-specific rules, which is something we are always a bit shy of in UNCITRAL, and to address broader challenges presented by the use of artificial intelligence and other emerging technologies in dispute resolution, including through the use of platforms to settle disputes. You will hear more from Cédric on how we plan to conduct further analysis on technology-related disputes, which would further inform the Commission on possible future work. We're also engaging closely with the government of Hong Kong, SAR, which opened a dedicated office to collaborate more closely with UNCITRAL in November 2020. One of the first projects expected is the launch of an inclusive global legal innovation platform on online dispute resolution. In the acronym would be IGLIP, which would aim to keep track of issues arising from the application of emerging technologies in online dispute resolution, that we also call ODR, and to provide an inclusive forum facilitating continued discussion, collaborative knowledge sharing, and creative problem solving. As you may know, UNCITRAL had previously conducted work in this area, resulting in the 2016 UNCITRAL technical notes being prepared by the Secretariat on ODR, and it would be an opportunity for us and for the entire UNCITRAL community to revise this text in light of the increased use of platforms to settle disputes. Trading platforms with inbuilt dispute resolution and the use of AI in such platforms could also be of interest and closely related to our digital trade project. Lastly, the Commission in 2020 considered a proposal put forward by the Japanese government that the Secretariat should conduct activities, including research and the hosting of expert group meetings, webinars, and online consultations, such as the one we are holding today, to collect and compile information on the latest trends regarding international dispute resolution. Takashi will be presenting this proposal more in detail, but there are quite some support in the Commission, and it was widely felt that the Secretariat should explore possible means to implement such activities and report back to the Commission this year. Considering that there are so many DRDE, dispute resolution in the digital economy, DRDE topics on the horizon, the Secretariat has decided to combine all relevant projects into an overarching theme, dispute resolution in the digital economy. Considering that the Commission has emphasized its central and coordinating role within the United Nations system in addressing legal issues related to the digital economy and digital trade, the Secretariat will continue to develop a taxonomy and refine the scope of topics identified as part of its ongoing exploratory work. But now to today's kickoff discussion, we will be hosting a number of events in the first half of the year, as Jay mentioned. And in summary, we will be preparing a working paper for the Commission that could have following subcomponents: the use of technology in traditional dispute resolution, that would be remote case management conferences, hearings, taking of e-evidence, technology-related disputes, online dispute resolution platforms and relevant developments, and stock taking of developments in dispute resolution and the way forward. That paper would then analyze the recent developments, identify gaps, needs, seek areas where future work by UNCITRAL could be explored. And it would also review existing UNCITRAL text on dispute resolution and their relevance and see how future-proof they are. Our aim is to present concrete proposals for legislative work for consideration by the Commission in the coming months of June. So I would like to urge all of you to stay tuned on the different events that will be hosted in the first part of this year. And I'm really looking forward to your continued participation. Please indicate to us if you have any interest and expertise that you wish to share, or also if you know of relevant experts as we pursue further harmonization of legal standards in dispute resolution. And with this, I wish all of us a very fruitful discussion and deliberations. And the floor is back to you, Jay. Thank you.
Thank you, Anna. As you know, 75 minutes is quite short to discuss all these topics. And I know that we have a lot of attendees currently in the room. So if you have any questions with regard to anything that the speakers are saying, please feel free to post those questions in the Q&A below, which is probably provided to all attendees. Now, next speaker is Takashi, who will be presenting, as Anna mentioned, the Japanese proposal that was made to the Commission last year. Now, Takashi Takashima is the senior attorney in the Litigation Bureau and the Minister's Secretariat International Affairs Division of the Japanese Ministry of Justice. He engages in formulations of Japanese government strategies on international disputes and has functions as representative in a number of meetings in UNCITRAL and ICSID. Now, in addition, he serves as the rapporteur of UNCITRAL's Working Group 2, has served as a judge of various domestic courts in Japan, and has diplomatic experience as Second Secretary of the Permanent Mission of Japan to the United Nations. So with that, Takashi, can you tell us a little bit more about the Japanese proposal on stocktaking of dispute resolutions developments? Thank you, Takashi.
Yes, sure, my pleasure. Thank you, Jay, for the introduction, and also many thanks to Anna for the wonderful opening presentation, which makes a perfect segue into my own. In the time allotted, I would like to briefly give an overview on Japan's proposal on the stocktaking of dispute resolution in the modern context. Let me begin by touching on what this proposal is about and why we are advocating it to go forward. In recognition of the wide range of developments in the area of dispute resolution, this project is aimed at compiling relevant information on the latest trends on the ground in that area. If you are familiar with UNCITRAL, amongst the various roles that UNCITRAL plays, you may know that legislative work and technical assistance activities are key roles which UNCITRAL plays in the field of international trade law. This stocktaking project is unique and interesting in the sense that it lies somewhere in the middle between legislative work and also technical assistance activities. We are very hopeful that by carrying out the activities as proposed, it will lay the groundwork for future legislative work, and also by making available information on the latest practice in the area, assist capacity building. In terms of timing, we were prompted in a way by the pandemic when we put this proposal forward, but it should be made clear that the aim of this project is not COVID-19 response. The need for stocktaking was already there even before the pandemic, and in our view, stocktaking of development will continue to be relevant during and also after the pandemic. By way of example, speaking of one topic we see merit in looking into, we can probably all agree that the increased use of remote proceedings is one of the most significant transitions that has occurred amidst the COVID-19 pandemic in terms of dispute resolution. Due to travel restrictions and safety concerns, remote proceedings in arbitration and mediation through the use of video conferencing platforms, as we're doing right now, have become standard practice. It seems likely that the use of remote proceedings will continue to be present even after the recovery from the pandemic. While remote proceedings have benefits such as saving costs and time that would otherwise be necessary to be physically present at designated facilities. They are different from in-person meetings in many ways, and it has become acknowledged that remote proceedings may have their own limits. There seems to be broad recognition that time is limited and there are due process considerations to be had. As such, it seems to us worth asking the questions, what are the obstacles and for what reason? How can they be overcome? And how can we preserve or even further strengthen due process and fairness? We believe that an accurate understanding can only be fostered through a thorough study on what's going on in practice in the field of dispute resolution, and that such a study is indeed what is needed. Because this is a kickoff discussion, rather than wrapping up towards the end of my presentation, I will put more issues on the table. Allow me to take a moment to put a slide on the screen. So here it is. This is a slide which we used when we advocated for support to our stock-taking proposal. Our thinking has evolved since then, but I still think that this slide is good to show the breadth of issues that this project can actually cover. On the substantive side of issues, it's not hard to imagine that the increased use of electronic means in entering into contractual relationships has given rise to new forms of disputes. We also see here that the enhanced use of AI is another new factor to be considered and an issue that work is already in progress in UNCITRAL, as we've heard from Madam Secretary. On the procedural side of issues, in addition to remote proceedings, we have listed issues pertaining to expedited settlements of disputes, online dispute resolution, handling of electronic evidence in dispute settlement proceedings, and utilizing tools tailored, for instance, for high-tech dispute settlement, and etc. Again, my intention here is to show that this project will enable us to look into further in-depth what we already know about and open the doors for research on a variety of issues that still remain not very well known to us. To make the most of this project, it is of course extremely important to identify the right issues and carry out the right activities. To this end, we are holding on, we, meaning the Japanese Ministry of Justice, UNCITRAL, and JIDRC, we are holding online workshops on March 30 and also on the 31st, 2 consecutive days, and hope that you'll be able to join us then. I also would like to invite UNCITRAL experts and other professionals in the field to share with us your views on what practical issues you think would be worth studying through this project on stock-taking of dispute resolution. With that, I conclude my presentation, and back to you, Jay.
Thank you, Takashi. As you mentioned, we have a lot more questions to answer than answers to give today. Next, I'll give the floor to Andres Hana, who is one of the persons that I've been talking to most this year, I think, apart from my family. Andres Hana is a senior partner at Bartholomew Alvarez Hana Abogados in Santiago, Chile, and he also teaches private law at the University of Chile. He's a counsel and arbitrator in international disputes, both commercial and investment, and he's been a delegate to Chile to UNCITRAL Working Group 2 since 2007, and now he is currently serving the working group as the chair of the working group. Today, he will be discussing the current status of Working Group 2 and what can be expected of the upcoming sessions and possibly following the commission. Andres, you have the floor.
Thank you. Thank you very much, Jay, who, as correctly said, has become family in the last year. Well, I would like first to thank you very much for this invitation. It's an honor to be speaking here. It's a good morning and a good afternoon to everybody. And in particular, I would like to thank the Ministry of Justice, the JIDRC, and of course, UNCITRAL. I've been asked to speak about the current status of the Working Group 2. and also the possibility and what is the possible work ahead of the working group. Let me start by saying that in that regard, that the working group 2 has been focused in the last 2 years in developing expedited arbitration provisions. This work of the working group, I think, has to be framed in the idea of the Commission that the working group should focus on the improving of efficiency of the arbitral proceedings and the reduction of costs. At the beginning, the Commission and the working group consider, what work can be done in order to achieve that, and explore the possibility of developing expedited arbitration provisions, and also looking at emergency arbitration and adjudication in construction contracts. And the group decided to first focus on the development of expedited arbitration provision, and this has been the focus of the working group for the last, I would say, 2 years or a bit more. Why focus on expedited arbitration provisions? Well, I would say that there has been a very long-standing already, I would say, sentiment and concern in different users around the world with respect to international arbitration, that international arbitration takes too much time and costs too much money. So it has been not efficient, not from the point of view of time, not from the point of view of cost. And I have to say that studies and statistics show that time and cost are closely related in a proceeding. The more time a proceeding costs, the more money, the more that also will cost to the parties. And this explains why around the globe, and Kevin can speak a little bit about more about this, you will see that expedited arbitration provisions in the last few years have been starting to, I would say, appear and also impose and become a very strong trend. Actually, I have to say that the statistics are very impressive in terms of the development and the use of expedited arbitration proceedings or accelerated proceedings, as they also call, around the world. So let me briefly say what we talk, or what we have been doing in the working group, what we talk when we speak about expedited arbitration provisions. What are the goals there? Well, I would say that if we try to express this in a very expedited form, a very simplified form, the purpose of the expedited arbitration provisions is to acknowledge that there are certain disputes, a number of disputes that can be resolved in a more efficient and shorter way. Say differently, the idea of expedited arbitration provisions is to streamline and simplify the procedure in order to reach a final resolution of the dispute in a much more cost and time-effective manner. If you look at the features of an expedited provision, you will find that the idea is that everything can happen faster and also in a more economic way. When I mean economic, I'm speaking about in terms of the stages of the proceeding. That the arbitrator will be that there will be one arbitrator, not three, that the arbitrator will be appointed as soon as possible, that instead of having 2 rounds of written pleadings, you will have ideally one. That may occur that the dispute will not resolve with the hearing, that the evidence will be also taken into account in a much more, I would say, in a much more streamlined way, etc., and etc. So if you look at the proceeding, you will find again that everything, as I repeat, happened faster and also happened with probably less stages that you will find in an ordinary proceeding. And probably this is the reason why you will see that around the globe, these expedited arbitration provisions has been so successful. I recognize that I have some bias and I have some interest on it, but my impression has been from the beginning that expedited arbitration provisions are the future in a sense that they will become more the rule than the exception in the future. And why is that? Because I said, if an expedited arbitration proceeding is able to resolve the dispute in a fair manner, that's it, respecting, of course, due process, but doing it in a much more an efficient way. So, and actually, if you see about the you think about the importance of expedited arbitration provisions, you can see that during the pandemic, several of the features of an expedited arbitration proceedings or provisions has been proposed and encouraged by different arbitral institutions. If you look, for example, you take the ICC note, you will see that the ICC note suggested that during the pandemic, certain of the features of expedited arbitration proceedings will be adopted in order to, solve the dispute. So, having said that, let me use my final minutes very quickly to explain where we are and what we expect from the future. After, as I said, 2 or more years of work, we have been, I think, efficient, and we are ready in our next session, I would say, which is in March, and the end of March to 2021, we are ready to finalize the rules. I think that the working group is very close. There are only very few issues remaining, very close to adopt the rules as working group in order to propose them and to the Commission as an expedited arbitration provisions of UNCITRAL. We still have some issues to finalize. One of them is the form, for example, the format, but we think that we are very close to approve in the group our rules, very few issues remaining, and I'm confident that notwithstanding the difficulties of the past year, we will be able to finalize the rules and present the rules to the Commission for its adoption in the summer. Not my summer, but in the summer of 2021, and means in the Commission in July. Something that I would like to say that has been very interesting in the work of our working group. I don't have time to go, of course, in every detail, but something that was mentioned by Madam Secretary is that we have to discuss this in the middle of the pandemic, and we took profit of that. And how we took profit of that is that we recognized that what was happening in the pandemic, as I said, in many aspects will be the rule, not the exception. So the working group decided to adopt a general provision on digital means. So we made, as I said, a general rule that the arbitral tribunal will have the power to adopt any form or the use of any digital means to communicate with the parties, to consult with the parties, and to also hold hearings. And this has received a very broad support. So we already have in the rules, as in the provisions, as a rule, the use of digital means and the power of the tribunal to use digital means. So one next, and I'll finish here. One next. Well, after we finish the rule, and we expect that the Commission will adopt the rules in the summer, as I said, we expect to finalize the explanatory note. We will accompany the rules, explaining how these rules can be used and help with the user friendliness of the rules. And we expect that we will be able to do that after following the Commission. And from there, I think that the working group is open to receive, the possibilities of how to handle any future work on dispute, the resolution on international arbitration. Thank you very much, Jay.
Thank you, Andres. You took my role of the timekeeper away because you kept the time. Now, when we're talking about dispute resolutions, we're not only talking about arbitration. Of course, we have been focusing on arbitration, but we had the entry into force of the Singapore Convention on Mediation last year, and we're also talking about mediation. So we also need to look at how mediation might change with the use of technology. Next speaker is Mr. Professor James Claxon. He's an arbitrator, mediator, and a professor at Waseda University and Ricoh University in Tokyo. He has previously practiced international arbitration in Paris and was a legal counsel at ICSID. And I think, James, you'll be looking into how the recent trends in remote mediation so that we can have a view of both arbitration side and as well as the mediation side. James, you have the floor.
Thank you very much, Jay, and thank you to the organizers for having me. In particular, thank you to the Ministry of Justice for the invitation. As mentioned, I've been asked to provide a short survey of remote mediation and recent experience with remote mediation. For at least a decade, there have been a growing number of advocates of online mediation proceedings, but remote mediation has not been widespread. The COVID-19 pandemic has changed this by forcing many mediators to move their practices online. Now, with more than a year of collective experience, it is possible to begin taking stock of the bad and the good. There are limitations online. There can be technological problems, including weak internet connections or issues with hardware like microphones. This can make the process unworkable or unbalanced, where communication with one party is easier than with the other. There can be logistical complications, such as finding a convenient time to mediate when participants are spread across time zones. Communication may also be less natural online. Despite these challenges, mediators have adapted to the online world, even as telecommunication services have adapted to mediation. Online platforms have improved security and have made tools that are helpful for mediation, like breakout rooms and screen sharing, easier to use. There are more options. Zoom and Microsoft Teams now compete with a growing number of dedicated dispute resolution platforms, including CREC, Modron Spaces, and Legaler. In parallel, support services have improved. Language interpretation, for instance, can be easily integrated online with Kudo or Interprefree. Mediators have meanwhile adjusted their practices and sometimes their sleeping patterns to accommodate online cross-border proceedings. Mediation days are often shorter, with more breaks, because a long period staring at screens is tiring. To avoid technical problems, mediators circulate online protocols to parties before mediation and meet with them online to test the technology. Remote mediators have also learned to communicate more effectively by ensuring that parties use cameras when possible and by mastering the important and very unnatural habit of staring directly at the computer camera when speaking. For most mediators, these changes mark a significant break with their established practices. Yet many mediators who were skeptics have now come to be proponents of online mediation, and some say that remote mediation will now be a regular feature of their practices. An assessment of online mediation does not need to begin and end with the issue of how physical mediation can be cut and pasted into Zoom. Online mediation has the potential to improve international mediation practice generally in three important ways. First, there may be more scope for mediation online. Mediation of small cross-border commercial disputes is more likely because online mediation is cost-effective. At the other extreme, complex multi-party mediations are more likely online because distant mediators and parties can be brought together more easily. Meanwhile, claims that are on their way to arbitration or litigation may be easier to intercept because mediations are easier to convene. Second, the online shift may mean that mediators of the future are better trained and more diverse. The pandemic has seen a rise in online mediation training, accreditation, and continuing education courses, some free of charge. The Center for Effective Dispute Resolution, the Chartered Institute of Arbitrators, the Harvard Program on Negotiation all offer trainings online, while Sage Mediation in Singapore, for example, offers trainings that are specific to international commercial mediation. With a reliable internet connection, it is possible to become an accredited mediator or to hone your skills as a mediator from anywhere in the world. The third, mediations can be better tailored to disputes. A common commercial mediation might comprise a day of mediating with all parties present at a location at the same time. This format can have strategic advantages. It also results from the practical realities of scheduling, including travel, lodging, and venue reservations. Freed of these constraints, different models of mediation are possible for different kinds of disputes. For instance, mediation can be decompressed into a series of shorter meetings over the course of a few days to enable a mediator to devote more time to distinct issues or discrete relationships in multi-party proceedings. The online space also makes it possible for distant mediators to work together more easily in co-mediation. This can bridge linguistic or cultural divides between parties, which may help mediation to penetrate new markets. Online mediation can also be integrated more easily into other forms of dispute resolution. The convenience of online mediation may facilitate a second or third attempt at settlement over the course of an arbitration. It may also enable parties to simplify arbitration by disposing of discrete claims or procedural issues more easily. An empirical study by the London Chamber of Arbitration and Mediation and Herbert Smith Freehills, published this week, suggests that settlement rates for this type of mediation in arbitration are high. To conclude, the online space offers the possibility of a mediation process that is better tailored to individual disputes and that is more accommodating of new participants and new markets than physical mediation. Seen in these terms, the present moment of change is also an opportunity to reconsider how to better align mediation with the needs of a broader range of disputing parties. Thank you.
Thank you, James. So we've seen what Working Group 2 is doing on arbitrations. We've seen how the recent trend has changed in mediation. Next, we'll have Cedric, but just wanted to mention that the next three speakers all happen to be male, and we happen to have a full male panelist section at this panel, but the Secretariat values gender balance, and we hope to have the next panel of full female panelists so that we actually match that balance of gender. Cedric will follow with the proposal on dispute resolution in international high-tech related transactions. Mr. Cedric Saba is the Director of International Cybersecurity and IT Law Affairs at the Office of the Deputy Attorney Generals in the Israeli Ministry of Justice. He advises the Israel government on a lot of questions, cybersecurity, internet governance, AI, and information technology generally, as they relate to international law. He has served as the Israeli delegate to the UNCITRAL working groups and the Hague Conference on Private International Law, focusing on dispute resolution and technology, and probably that's where the proposal is coming from. Cedric used to work as an M&A and a high-tech lawyer in the firm of Abrahamson & Co. in Jerusalem, and maybe we can have a little bit of an insight of what we mean by international high-tech related transactions and what the Israeli proposal is about. Mr. Cedric Saba, you have the floor.
Thanks so much, Jay. It's an honor for me to be participating in this event. I wish to thank Japan's Ministry of Justice for our fruitful collaboration in the field of high-tech dispute resolution. We began our work together on this since 2019. There's still much to be done, and we look forward to continuing our constructive discussions with Japan and other partners and stakeholders from across the globe on this topic. As was mentioned before, the last few years have been pivotal for the field of international commercial dispute resolution. UNCITRAL adopted the Singapore Convention on International Settlement Agreements Resulting from Mediation. The Hague Conference on Private International Law adopted the Convention on the Enforcement and Recognition of Judgments. And UNCITRAL Working Group 2, chaired by our good friend Andres, who's on today's panel, is making very good progress on new expedited arbitration rules. Taken together with the 1958 New York Convention for the Enforcement of Arbitration Awards and the 2005 Choice of Courts Convention, we have a truly global framework for international commercial dispute resolution. Such a framework is all the more pressing in the context of the COVID-19 pandemic, which has already propelled the use of technology in dispute resolution and might also lead to increases in cross-border disputes due to the economic consequences and disruption in global trade. In the last few years, Israel made it a priority to enhance our legal framework for cross-border dispute resolution. We're now looking into ratifying the Singapore Convention, the Choice of Courts Convention, and the Judgments Convention in the near future. Israel is already party to the New York Convention, and we like to point out that we were the first signatory back in 1959. We're also filing a draft bill to adopt UNCITRAL's model law on international commercial arbitration, which we hope to be in a position to publish for public comments very soon. Israel is often referred to as startup nation, and indeed our high-tech industry, as Japan's, is quite vibrant. So we consulted with high-tech attorneys in private law firms, in-house counsel, and VC funds on all these developments. It was conveyed to us that these developments, while positive, did not address all of their needs. We were told, bluntly, that ordinary modes of dispute resolution were simply not entirely adapted to the fast-paced, highly specialized world of high-tech disputes. So with that in mind, we set out to challenge ourselves regarding our accepted notions of what dispute resolution should look like in today's economy. We also wondered whether these feelings were particular to Israel's high-tech industry or whether they were shared by high-tech players outside Israel. And this leads us to the proposal submitted in 2019, together with our dear colleagues from Japan, in which we sought to explore this issue at UNCITRAL. UNCITRAL seems particularly well positioned to discuss it, given both its expertise in developing dispute resolution text and its digital economy agenda. In that regard, we're grateful for the leadership of Ms. Sana Joubran-Brett and the excellent professional work of the Secretariat. So in the next few minutes, I'd like to just share with you briefly the contents of the Japan-Israel proposal, the insight and feedback we've received in the last few months on it, and where we are now and where we'd like to go from here. So the contents. When we started, we assumed that whatever work needed to be done should focus on arbitration. But one of the reactions we received when we consulted with experts was that we shouldn't focus on arbitration exclusively. There are, of course, different types of dispute resolution mechanisms, such as mediation, med-arb, and expert adjudication that should be considered, and perhaps even new ones that we haven't thought of yet. So you'll note in the original Japan-Israel proposal that it doesn't favor one type of dispute resolution mechanism or another. Also, we excluded from the scope of the proposal two important fields of activity, IP and B2C transactions, because each of these is governed by a unique set of rules, and UNCITRAL isn't necessarily the appropriate forum to deal with these issues. Still, the types of high-tech transactions that are covered by the proposal is very broad: deployment of IT systems, technology acquisitions, software license agreements, cyber insurance, and more. Our proposal focused on three areas that came up consistently in our consultations with industry: timeframes, expertise of the neutral, and access to digital evidence. Since the proposal came to light, we co-organized in collaboration with UNCITRAL, Japan, and the Czech Republic 2 additional events with practitioners and academics from all over the world. The overwhelming response to the proposal was that it's timely and very much needed. Some really interesting ideas were suggested. For example, to create a guidance note for neutrals on handling high-tech disputes with emphasis on case management. Another suggestion was to radically change arbitration to provide much shorter timeframes, even shorter than those of expedited arbitration, to limit the number and scope of written submissions and appoint an expert immediately at the commencement of the arbitration. Another suggestion was to create a more detailed framework to enable the neutral's access to digital evidence, together with specific confidentiality arrangements. These ideas all point to uncharted territories, and we're very much open to outside-the-box thinking so that more ideas can emerge. At the same time, in the course of discussions with some UNCITRAL colleagues on our proposal, we were posed a few challenging questions. One was, is dispute resolution in high-tech really that different that it requires special attention? Arguably, every field of activity requires that the neutral have subject matter expertise. And one key advantage of arbitration and mediation rules is that they're flexible. The neutral can adapt the rules and make special arrangements tailored to the unique features of a case. So isn't that enough? And to this question, our consultations with a plethora of experts indicated that, well, no, current frameworks are not adequate because the default rules need to change and they need to be spelled out more clearly for parties to have greater certainty and confidence in the process. And so that neutrals facing high-tech disputes are better equipped from the start to manage these cases efficiently. Neutrals should not have to reinvent the wheel every time. They can handle these disputes more efficiently by having at their disposal an adapted framework for high-tech disputes. So let me just provide one example. One of the key issues raised during our consultations was the need for shorter timeframes because high-tech companies, particularly SMEs, need their disputes to be resolved very, very quickly. Now, the shorter the timeframes, the greater the risk that certain substantive claims by one of the parties will not be fully addressed. In a typical case, a neutral will tend to err on the side of caution, allowing the parties to submit more documents so as to avoid harming the parties' due process rights. UNCITRAL guidance on balancing evidence management with very short timeframes could create certainty for the parties and for the neutral as well. Another issue that we've been asked was, why UNCITRAL? UNCITRAL as a UN body strives to develop legal instruments that are beneficial to the entire international community as a whole, and not to one particular sector. It's important for UNCITRAL to focus on topics that lend themselves to global application or harmonization, and we would not want UNCITRAL to select its work based on the needs and interests of just a small number of states. Our approach here is fully consistent with this goal. We see high-tech dispute resolution as a cross-cutting issue because high-tech permeates international trade. It's not just about disputes between two high-tech startups. It can conceivably include disputes between, say, a cloud provider and a toys retailer, or a cybersecurity firm and a shipping company. More importantly, focusing on high-tech dispute resolution is crucial to the millions of SMEs all over the world, both in developed and developing countries, that want to foster innovation and growth. The topic is simultaneously cutting edge and universal. So we very much view this as a subject of general application, which UNCITRAL is particularly suited to address. We were glad to see broad support for continued exploratory work on the proposal during the last commission, and the Secretariat was tasked with continuing this work and providing some data and suggestions for next year's commission. So where are we at now? Well, we are currently collaborating with the UNCITRAL Secretariat in organizing an experts group meeting, bringing together, again, practitioners and academics from across the world. We will build upon the findings and insight that was gleaned from the 2 previous workshops and further refine the questions and issues, as well as building on the digital taxonomy developed by the Secretariat. It is hoped that the experts group will assist the work of the Secretariat so that the 2021 Commission will be in a good position to decide on future work and hopefully to allocate one of the working groups that are in. We at the Ministry of Justice very much look forward to continuing our work with our partners in Japan, the Czech Republic, the UNCITRAL Secretariat, delegates to UNCITRAL groups, and the experts who are dedicating much time and effort to this endeavor. The road ahead might be a little bit buggy, but like any ambitious project of this sort, but I'm optimistic that all of this will bear fruit and that the tools to be developed will indeed make an impact. That's it for my presentation, and I'm happy to answer any questions you may have.
Thank you, Cedric. And as Cedric mentions, if any of the listeners have any questions, please feel to pose them in the Q&A, and we have received already 2 questions, and I have already assigned them to the 2 speakers. Next, I think we'll have to go see what is actually happening on the ground. We have 2 practitioners who are actually on the ground administrating disputes, and the next speaker is Kevin from the JIDRC, who is the Deputy Registrar and Center Director of the Singapore International Arbitration Center. He oversees the administration of thousands of international cases and has significant experience in SIA cases involving expedited procedures, emergency arbitrators, and early dismissal of claims and defenses. So he is a frequent speaker on issues related to arbitrations, and therefore we'd like to see hear the view of the arbitration institutions and what has changed over the recent years in the realm of international arbitration. Kevin, you have the floor.
Thank you very much, Jay, and thank you to the Ministry of Justice of Japan, JIDRC, and of course the UNCITRAL Secretariat for organizing this very important dialogue. Perhaps one of the best recent examples of the power of operating in the virtual space and the way that arbitration can leverage off the technologies is the fact that the last session of Working Group 2 was conducted fully remotely. And when you look at arbitration, really arbitration has been preparing for this for quite some time. The difference now is that we're seeing fully remote hearings. Previously, it might be the case that a hearing would be conducted physically and you might have a fact witness or an expert witness participating remotely. The real change has been to have fully virtual hearings. I'm going to give the view from Singapore and the Singapore International Arbitration Center and look at how these arbitrations have proceeded during the course of the pandemic, practical considerations, and maybe some lesson learned on what has really become the next phase of arbitration and how does arbitration emerge from this pandemic. To frame the discussion to a certain degree, there are many questions that arise for consideration. The first for parties and arbitrators is when is it appropriate to hold a virtual or remote hearing as opposed to a physical hearing? How do we maintain confidentiality and data security? This is particularly important for institutions that are controllers of data, due process concerns, natural justice, and then the eventual risk to the enforceability of the award. One thing that's been very heartening about arbitration is really how the institutions are all working together. I will particularly be interested to hear from JIDRC, but many of the institutions have gotten together, signed a joint statement that the institutions are going to work together to help these disputes proceed during the course of the pandemic. We've seen many institutions releasing guidance. There was the SOL protocol, the Delos checklist. SIC has released a guide for taking your arbitration remote. We have framed this as a checklist. What we are trying to look at is really the practical considerations for hearings. So even if a practitioner or a tribunal has not done one yet, or if they've done many arbitrations, that they can look at this checklist and decide whether or not it's appropriate to conduct this hearing remotely. Arbitration is particularly well suited for operating in the virtual or online space, and also because of some of the procedural rules. Most institutions now have a procedure for fast-track arbitrations, as Andres was mentioning. SIC has been really active in this space. We've had more than 600 applications for the expedited procedure. What is an interesting element here is that now parties are quite aware that their arbitration is going to be fully resolved during the course of the pandemic. So this is affecting written advocacy, oral advocacy, strategic and tactical considerations. With the advent of the Singapore Convention, SIC has a joint protocol with SIMC, an ARB-Med-ARB protocol. This is becoming more attractive as well. Companies are sometimes facing liquidity concerns. And I heard it put in an interesting way that sometimes during the course of the pandemic, there's a dispute that's really nobody's fault. There's not an issue or dispute over fact. A party wanted to pay, was unable to pay or take delivery because of the pandemic. And this might be appropriate, particularly if it's a long-term relationship, to resolve this through mediation. And then, of course, early dismissal, which we've been discussing in Working Group 2 as well, on those cases where the facts are not in dispute, where it might just be the contours of the force majeure clause. This can be particularly suitable for early dismissal. One thing that we have been particularly pleased about is how quickly parties are adapting to the use of remote hearings. I think that most arbitral institutions were looking at this as being the smaller, more simple cases, but there have been very high value, complex, multi-jurisdictional cases. We have remote hearings that might involve 3 or 4 continents. What we've tried to do from an institutional standpoint is to make sure that we always have an SIC legal counsel also on the virtual hearing, and it has proceeded quite successfully. But of course, you can imagine that there are some concerns on a virtual hearing, and you need to look at the procedural rules. So SIC is advantaged by the fact that the SIC rules provide the tribunal with very broad discretion. And the typical issue that will arise, you might have one party requesting a virtual hearing and the other parties objecting and saying that they need a physical hearing. You could have both parties saying that they want a virtual hearing and the tribunal wanting to push it back and go for a physical hearing. And then also both parties saying they want a physical hearing and then the tribunal wanting to proceed with a virtual hearing. This is going to be case specific. It is again going to depend on the institutional rules, the governing law of the contract, governing law of the arbitration agreement, lex arbitrii, and the tribunals need to take those into consideration. And we are seeing tribunals being quite prudent, but at the same time, being able to marshal the proceedings. There was a recent decision from the Austrian Supreme Court that has helped shape the discussion on the tribunal's ability to decide. There are, of course, challenges if tribunals are going with remote hearings. You have to look at potential asynchronicity. How do you deal with the different time zones? What we're often seeing SIC tribunals doing is flipping the schedule. So one party is not always submitting very late at night while the other side is submitting during the course of the day. There's also potential issues of asymmetry. If you had, say, 2 out of 3 tribunal members that are physically in person and then a co-arbitrator that is operating remotely. We've been very fortunate in Singapore because physical hearings are going on. And sometimes we'll see situations where you might have the presiding arbitrator of a 3-member tribunal in person alongside both sets of counsel, and then both arbitrators dialing in remotely. In terms of some other challenges, of course, we see counsel sometimes suggesting that it might not be quite as easy to cross-examine witnesses remotely. Issues of witness coaching. Arbitration has come together and addressed most of these concerns, and now we're hearing some counsel and some arbitrators saying that it is somewhat easier for the examination of witnesses when it's done virtually. If you had a lay witness that is not used to being in a big physical hearing, maybe it's a bit easier in a virtual hearing. There is the possibility of picking up micro expressions, so there are advantages here as well. So we've addressed the challenges, and just to quickly canvass some of the advantages, because I think that this is important for how arbitration emerges. As has been said, it certainly saves time and cost. As we come out from this pandemic, you can almost put the provocative question, will there ever be another case management conference held in person? Or will these start to be held virtually as a matter of course? It's important for arbitration to consider its carbon footprint. We are now able to operate around the world without having to get on airplanes. And this has really made a bigger tent, both for counsel to participate in hearings and also for the appointment of arbitrators. I guess ultimately, the fundamental tenets of arbitration remain the same. And one of the biggest advantages of arbitration, in addition to it being a creature of contract, is that it is highly customizable. And what we are seeing is parties customize their procedure to be able to work during the course of the COVID-19 pandemic. Thanks very much, Jay.
Thank you, Kevin. I think about this time last year, I was not aware of Zoom. I was not aware of Teams. Yeah. And now everybody is on Teams and Zoom. So now we're actually we're hosted by JIDRC, and everything is going smooth. And we'll be hearing from JIDRC experience of using technologies on online and hybrid hearings. To do this, we have Professor Yoshihisa Hayakawa-san, who used to be a delegate for UNCITRAL's Working Group 3 that prepared the UNCITRAL technical notes on ODR, and has also been influential in implementing that ODR technical notes in the APEC context. So with that, Yoshi, you have the floor.
Thank you very much. And I'm now serving as the Secretary General and the Executive Director of the Japan International Dispute Research Center. We call it JIDRC. And I'd like to show our experiences of online or hybrid hearing for the international arbitration and mediation. And so I will use the slide. So first of all, let me briefly introduce our organization. So it is a newly established entity for the promotion of international arbitration in Japan and to operate new facilities for the hearing of arbitration. So we are now using our facilities. The aim has been one of the important governmental policies of Japan since 2017 with approximately $8 million budget. So in March 2020, the new facilities for the hearing of arbitration was established in the center of Tokyo. Now I'm here. So we have several tasks, and one is a promotion of international arbitration to the business cooperation in Japan, and PR activities of international arbitration in Japan to the foreign stakeholders, and education and training for the human resources on international arbitration in Japan. But one more important thing is we are providing facilities for international arbitration with advanced technology in Tokyo. So this is pictures of our institute. And we are not International Arbitration Institute. We are only just providing venue for the hearing for international arbitration mediation. But fortunately or unfortunately, our facility was completed at the time of the end of March 2020, in the middle of the pandemic, or at the time of the beginning stage of the pandemic. So at the time, we had most advanced facilities here in JIDRC. And after the opening day, unfortunately, we had to close our facilities because of the state of emergency issued by the Japanese government for 2 months. But during these 2 months, we tried to improve our facilities much more, try to reflect to the serious need for the remote hearing or hybrid hearing in international arbitration. So this is one of the scene we had been prepared for the international hearings. So nowadays, the hybrid style is the gradually or more used for the international arbitration, as Kevin said. So sometimes we have to provide 2 or more cameras for the hearings and try to combine other places where arbitrator or witness is located. So in other words, we always try to connect 2 or more physical places and try to operate very smoothly international arbitration by the remote access systems. Why it's not a pure virtual one? Because the due process is the most important issue in the cross-examination in the hearings. But unfortunately, there is a risk. For example, the witness may hide some, his or her smartphone on his knees and try to receive the message from his own counsel, or sometimes they have to use a earphone, but the coaching voice could be received by the earphone, and so this kind of the cheating behavior should be avoided. So we have to provide very secure and safe and so the advanced facilities in each jurisdiction and try to connect each places by the remote access. That is a hybrid style. For this purpose, we try to provide various types of the cameras for the hearing rooms, or sometimes for the breakout rooms. So with these technologies, now we can provide very smooth hearing environment with 2 or more other physical places connected by the remote access system, including Zoom and including Microsoft Teams. So other important issues are translations. We improved our translation booth. So translator can easily use their very accustomed the translation booth. And these voices can be heard. For the on-site participants, they can use their own, the receiver for the translations. And also, these voices are directly connected to the Zoom second language system. So the translator's voice can be heard by the receiver for the on-site participant, or for the by the second channel of the Zoom for the online participants. This is another improvement issue, and we are providing this facility always. And the additional one is a transcript service by artificial intelligence. And but at present it is a little bit premature, but and limited time. And I will explain these issues and other opportunities. So anyway, so thank you very much to give me an opportunity to introduce JIDRC and our experience in the COVID-19 situation. Thank you very much.
you, Yoshi. Now, actually, we have about 10 minutes for Q&A. There have been a number of questions that have been posed in the Q&A, and if you do have any questions, please do so. Just to summarize, we have a question from Christopher Lanes on why does remote hearing raise due process concerns? I think Yoshi touched upon a few of the due process concerns otherwise. We have a question from Amin about MedArb in the context of expedited arbitrations, and also from Spianat about the difference between expedited arbitration provisions and fast-track mediation. We also have a specific question from Peter Harris to Professor Claxton that there is the benefit of mediation of meeting in person and reconnecting, and kind of that is the key benefit of mediation, and how online mediation can also have stimulus that kind of a reunion between businesses when they have disputes. And there's a question to Yoshi about the current caseload at JIDRC, but I note that JIDRC is quite a recent, it opened quite recently, so it's going to be the recent year or so of your experience. A general question that I would like to pose to all of the speakers is, in light of the discussions that we have had today, what do you expect from the Commission? And what would be the priority project that the Commission should embark on in the field of DRDE, as we call it, dispute resolution in the digital economy? So those are the questions that I would like to pose to all the speakers. We will go in the order of the speakers as they spoke. So the first respondent would be, and then we'll close with Anna's remarks. So the first respondent would be Takashi, please.
Thank you, Jay, and I thank the participant for posing the question. I believe the question was why may remote proceedings may raise due process concerns, and I'm not quite sure if I really said due process concerns, but rather I intended to say that due process considerations to be had. But in any case, I think I should mention 2 points very briefly, 2 points. One pertains to time, and the other is about technical issues that has already been discussed, but I will put it in my own words about this. I think that the different time zones are something that is factored into, and we do have this issue about getting together at one time frame altogether, and it seems that even in UNCITRAL meetings, time is limited to get together, and due to that time constraint, we are all faced with limited opportunities to convey our messages, and that is quite something that happens, obviously, in remote proceedings as well, as I understand it. And the second point is the technical issues. This is based on my own kind of unfortunate experience. And there was a remote proceeding that I attended, and I had issues hearing what the opposing party was actually saying. So that, in a sense, kind of deprived my opportunity to respond to what they were saying. So I thought that was a very primitive, but an issue in remote proceedings. So, but again, by taking appropriate measures, I am very hopeful that we will improve the overall quality of remote proceedings together. And let me just proceed to respond to the general question that you posed. What do we expect the Commission to do in the upcoming session? Just a very brief point, a practical point. We see merit in carrying out further research. The point we see merit in carrying out further research is what arbitral tribunals and institutions do to ensure effective communication with the parties, how case management conferences are utilized to clarifying the disputed issues, and also how document production procedures can be further improved with a specific focus on electronic documents. But again, these are only examples, and perhaps our current thinking is kind of evolving and maybe fixed to our traditional mindset. So we reiterate our openness to exploring new ideas. Thank you, Jay.
Thank you, Takashi. I might have to rephrase my question to indicate one project, not so many things to do. Andreas, you have 1 minute to respond to the questions that have been posed.
Thank you. Thank you very much, Jay. Well, the question that have been posed to me has to do with the relationship between expedited arbitration and mediation, or fast-track mediation and expedited arbitration. What I can say is that generally what we are doing is developing expedited arbitration provisions for arbitration. But obviously, as Kevin said, and James can further elaborate on this obviously can be combined with mediation, and there are certain cultures, legal culture, where this is very often, which is like mine, that there is a combination. But in principle, besides this combination that I think is obviously expected, the expedited arbitration provisions focus on arbitration as being, general with the rules that in arbitration has developed UNCITRAL before. Well, I mean, in 30 seconds or 10 seconds, with respect to the general question that you just mentioned, I think obviously that I would take the position that Takashi took and said that, that this is preliminary. But the only thing that I would like to say is that what is important than any further work that the group will take, the working group will take, I think it would be important to remind, one, that the working group is always doing work that is relevant for international arbitration. And I think this is very important, that this is a worldwide institution that has to deal with something that is relevant universally. And that relevance has to be taken into account. And my view is that everything that's happening in the world very fast, and we are trying to adapt that, needs to be digested and further think of. And I think UNCITRAL could be one of the best place for doing that type of thinking, of course. Thank you.
Thank you, Andres. James, so can online mediation reconnect people as they do in-person mediation?
Yes, thank you very much, and thank you to Mr. Harris for a great and difficult question. Of course, it's impossible to entirely replicate the physical experience of meeting, but I think there are things that a mediator can do in advance to set the stage for real reconnection between parties. That would be assuring that the parties use their cameras, being sure that there are limited distractions. Of course, cats and children see the opportunity of an online mediation as a chance at stardom online. So to encourage the parties to try and limit distractions, to make sure there's enough time given for the mediation. And then once the mediation is taking place, of course, the mediator can make process decisions. For example, bringing the parties together in a joint session to allow them to interact if the level of acrimony has gone down. So those are a couple of thoughts about what can be, and I think within the limits of the online space.
Thank you, James. Cedric, you've already touched upon some specific areas where future work of the Commission may evolve. But do you have any responses to the general question on what should be prioritized?
In terms of the substance of high-tech dispute resolution, we're still in the exploratory phase. So I hesitate to suggest one specific area. I think we need a little bit more data to have a better sense of exactly where UNCITRAL's attention is most needed. And this will also bear on the type of text that is most needed. Do we need a new set of rules, a guidance document, something else altogether? I recall in one conversation with an in-house counsel, we had somebody in a large high-tech company here in Israel. She told me they often reach suboptimal settlements because they don't have enough confidence, not in courts and not in arbitration. So the bottom-up process that we started, where we ask practitioners working in high-tech, what do they need? I think that's the right approach, but and my feeling is that ultimately some concrete text will be needed, maybe particularly around the issues of timeframes, case management, and evidence.
Thank you. I think there is a general consensus that there has to be more stock-taking and of actually looking at what the developments are. Kevin, any last views before we close with Anna's remarks?
Jay, I might take on the question of mediation replacing arbitration. I think that what we're looking at as dispute resolution professionals is there's a variety of ways of solving your disputes, whether it's arbitration, mediation, adjudication. As Andres pointed out, these may be combined. I think you do need to be careful when you're drafting tiered clauses. And I would also like to second James's point that sometimes you're able to mediate some but not all of the claims. And so there is a streamlining effect there. You could have 50 heads of claim, 45 of them are not particularly contentious. If you're in the arbitration procedure, you settle out those 45, and then you go back and deal with a reduced amount of claims in the arbitration.
Thank you. Yoshi, actually, you commented on the question from the benefits of online mediation. Maybe you can actually share that with the entire
Thank you very much. Very quickly, I served as a mediator for the Hague child abduction cases, and in that cases, one husband and mother, the wife is located in different countries, but we need several sessions. It is very difficult to travel abroad so many times for them. So the online mediation is very, very important for these types of the cases, even before the COVID-19 situation. Thank you.
Thank you, Yoshi. I think we are about to end. Maybe Anna, could you provide with the closing remarks? We are right on time, so you have 1 minute to close our session. Thank you, Anna.
Thank you very much, and thanks for your excellent timekeeping skills, all of you and our timekeeper. Thanks very much for this very interesting, challenging brainstorming that we had this morning. I was quite struck by how procedures such as arbitration procedures or mediation procedures, in spite of being procedures and having this rigid character to it, have actually been able to adapt to circumstances that have befallen all of us in an unexpected manner. So I think this is quite heartening, because it means that it is an area where we can work, where there is an open mind, an agility and ability to adapt, and I think that's very heartening. And also, I'm also struck, of course, by the vast array of issues and the many different topics that have been addressed this morning in this exploratory meeting. So thank you very much for your participation. And back to Jay to close our session. Thank you again to our colleagues and friends from Japan, from Chile, from Singapore, from Israel, and all of you who have joined us. Thank you, and have a very good evening or day wherever you are. Thank you.
Thank you. With that, we'll close. I would like to reiterate our thanks to all the attendees, including somebody who's currently waking up at 6 a.m., 5 a.m. So with that, I'd like to thank all the speakers and the attendants for joining us in our discussions today. As I mentioned, this is a kickoff discussions. We will be having more discussions to come, so we would like to have your inputs in the following series of discussions. Thank you very much, and goodbye to all.